The 21st century has impacted the way we communicate, share our lives, shop, and teach. We now have access to technology tools that let you reach students in ways that you never could have previously. But the 21st century has also brought privacy concerns. More and more, these online tools are collecting data about the users. How often do you click "I accept" without reading what you agree to? How often do you ask your students to click "I accept"? So what should a teacher do? What are your legal obligations? And what are the best practices for protecting student data? That's what this video is for. I'm going to explain your obligations and give you some simple steps to protect your students and you. There are three main laws that dictate how schools and teachers keep students and their data safe on the internet: COPPA, SIPPA, and FERPA. While there are slight differences in the focus of each law, who they target, and how schools are held responsible, all three are aimed at protecting students. Let's take a look at the first law, the Children's Internet Protection Act, or SIPPA. SIPPA requires districts to put measures in place to protect students from harmful or inappropriate online content. For school districts, this means that they must use an internet filtering system that not only blocks access to harmful content, but also monitors internet activity by minors. The Wausau School District uses two tools to comply with SIPPA. The first is Securely, which filters harmful content. The second is Gaggle, which monitors students' activity. These tools work together to actively monitor and protect our students, both at school and at home. The second law is COPPA, or the Children's Online Privacy Protection Act. While SIPPA was focused on protecting students from accessing harmful content, COPPA's goal is to protect others from accessing students' personal data. Anytime a student needs to sign into a website or app, COPPA regulations apply. COPPA puts special restrictions on software companies concerning the information they can collect about children under 13. Even though the law is directed at software companies, it still affects schools because of our use of educational tools and apps. The law mainly regulates personally identifiable information, or PII, that a company can collect. What counts as personally identifiable information? PII can include a name, email, address, birth date, student ID, or anything that can be used to identify an individual. It can also include combinations of information that together identify a person. For example, by themselves, an age or location or a first name might not be considered personally identifiable information, but in combination they are. So the most important thing is you shouldn't be sharing student information with apps or websites without parent permission. How do you follow COPPA and still use technology? You don't need a law degree to teach using technology. You just need to follow some simple steps. For any web tool or app that asks students to log in, first check its student data privacy status in the list of district trusted learning tools. You can find it on the Technology Department website, or you use the web address on the screen. It's easy to search and find the website, app, or software that you plan to use. When you find the tool that you want to use, check its data privacy status that is posted in red. Your administrators have reviewed the privacy policies of all the apps and tools listed and have given it a rating based on those policies. Each tool will be marked with one of the three data privacy statuses: District Contracted Tool, Student PII Not Collected, or User Agreement Required. COPPA does allow schools to act as an agent for parents for services that they are contracted with, such as Google, It's Learning, and Infinite Campus. Students automatically are given an account with these tools upon entering the district. These tools are marked as District Contracted Tool. Some tools do not collect student data, such as Kahoot and many iPad apps. These are marked as Student PII Not Collected. Most tools are marked as User Agreement Required. These tools collect student data, handles and protects it appropriately, but does not have a contract with the district. This means that a parent's signature on the iPad or Chromebook user agreement is required before you are clear to use it. That signature gives permission for student data to be shared with the company that runs the tool. If the tool you would like to use with your learners is not included in the list, you have two options. Both require you to read the educational tool's privacy policy and determine if students need to provide personally identifiable information and whether or not the tool practices safe handling of the information. Basically, if students are asked to type their name or email address into the tool, it means they're collecting information and you will need permission to use it. If the tool does collect data, you should also investigate how they store and potentially use that data. Check out the link to the video examples of what key features to pay attention to when reading a privacy policy. Once you have read the privacy policy and identify that it does collect data but stores and protects it, there are two options for using it in class with your students. Option 1 is to send out a parent permission slip. This can be done for each individual tool or as one permission that states several tools you plan to use. Make sure to include the tool, how it will be used, and which pieces of information students will be required to use when signing up. Parents must be given the option to opt out. The link on the screen will provide you with a template if this is a route you would like to take. The second option is to anonymize student data. This means that wherever you are asked to put a student's name, you instead put in anonymous information. So instead of a student's first name, you would put Blue, and instead of the last name, you would put Bonnet or Bunny. One example of this is Kahoot. If students are playing a Kahoot game their teacher created, students are asked to put in a nickname. This could be just their first name or a fake name. Anonymizing information could be unwieldy for you as a teacher to keep track of which student is Blue Bonnet and which student is Red Rover. And if students are putting other data into the system that could be construed as personally identifiable or as part of their student record, this still wouldn't do the job. You would still want to get parent permission. Now, if you teach students who are 13 or older, they are able to give their data to web tools and apps without parent permission. This does not mean you can skip the privacy policies. This is an opportunity to help our students make informed decisions on who they give their personally identifiable information to. Make your students aware that every time they click I accept or sign into a website or app, they could be agreeing to give away their personally identifiable information. And, depending on the app, they might also be giving away their rights to their photos, video, writing, or allowing the app to track their location. Review what kinds of information the company collects, how they use the information, and if they sell the information to third parties. Refer to the list of district-trusted learning tools to help guide you in deciding which tools and apps you will be using with your students and which ones to avoid. So let's review. If you want to use an online tool with students, check the list of district-trusted learning tools. For students under 13, most tools will require parents to sign a form giving permission for their child to create accounts for educational apps and tools, whether through the user agreement or one created by the teacher. The device user agreement parents sign at the beginning of the year will cover most apps. However, there might be a few new tools that an additional permission form is needed. Tools that are not listed in the district trusted learning tools need a little vigilance by the staff member, even if they are 13 or older. In some cases, anonymizing data with fake student names is sufficient too, but use discretion if the website collects other data. I recommend pausing this video, going to the address on the page, and spending a few minutes checking the list for tools you use with your students. While you are not required to, it is considered a good practice to notify parents of which tools your child will be utilizing in your classroom. So that covers how you handle student data with online tools, but there are other areas where you will want to be careful. This leads us to the third law, FERPA. FERPA is the Family Educational Rights and Privacy Act. There are two main parts to remember about FERPA as a teacher. First, schools cannot publish confidential education records for public viewing on the internet. Group-shared Google Docs counts as posting to the internet. A class list of students and missing work in Google Docs that has sharing permissions open up to anyone with a link could be in violation of FERPA. Encourage students and parents to use Infinite Campus for a much more secure and private way to view grades and missing work. Second, parents may request that their child's photos, names, and other personally identifiable information cannot be published. For educational technology, this means checking the user agreement signed by parents to make sure they gave permission for the student to create accounts. This year, we have 6 tips for keeping student educational records safe. First, be aware of writing down passwords. It puts students' data at risk of getting into the wrong hands, especially if you don't have them posted where others can see, on your desk or taped to your device. 2. Be careful about storing data in your cell phone, laptop, or flash drive. If you lose a cell phone, flash drive, or laptop, make sure to tell your supervisor so that the district can take appropriate actions in response. 3. Don't send student data to anyone who doesn't have a legitimate educational need for it. This is especially true of anyone not working for the Wausau School District, but even other district employees. Only send the data that is needed to the people who need it. 4. Be careful about putting student data into emails, as those emails could be considered an educational record, and keep in mind that parents and others can read the emails if they ask to see them under FERPA. 5. Don't store student data in online services such as Dropbox or your personal Google account. If you need to store student data in the cloud service, use your district Google Drive. 6. Even when you use your district Google Drive, make sure that the sharing permissions on the document, sheet, or folder are locked down as tightly as can be. You should not be posting grades or missing work in a shared Google Doc to large groups of students or parents. In general, be careful where you store student data and who you share it with. It's your job to keep student data secure. That's it. If you have questions, go to the Student Data Privacy page on the Technology Department website. All of this is on there, and many of your questions are answered there too. Now go out there and use technology to help every student succeed.